Hi, I'm MacKenzie Dickerman, and I'm joined by Rob Stone, and we're part of Alston & Bird's healthcare team. In late 2020, CMS and OIG released a set of final rules significantly updating the Stark Law and Anti-Kickback Statute. One of the key changes was a new set of Stark Law exceptions and AKS safe harbors for value-based arrangements, or VBAs. The new exceptions and safe harbors use a tiered approach based on the amount of downside financial risk. Essentially, the more risk that the parties take on, the fewer requirements that they need to meet in order for them to meet the relevant exception and safe harbor. Today, we're going to focus on a category of VBAs at the lowest end of the financial risk spectrum. Care coordination arrangements are value-based arrangements that require little to no downside financial risk. However, to satisfy the AKS safe harbor, they must be limited to in-kind remuneration only. There are several requirements for a VBA to qualify as a care coordination arrangement. Many of these will be familiar to anyone practicing in the fraud and abuse area. They include, among others, that the agreement must be set out in writing, it must be commercially reasonable, and it cannot induce the participants to limit medically necessary care. Rob is going to discuss several of the more unique requirements of the care coordination arrangements.
Thanks, MacKenzie. First, the recipient must contribute at least 15% of either the offeror's cost or fair market value for the in-kind remuneration they receive. Additionally, the parties must monitor and assess the arrangement annually to determine whether they're making progress toward achieving established outcomes or process measures. If they determine an arrangement resulted in deficiencies of quality of care, or that the arrangement is unlikely to further care coordination for the target patient population, then the parties must, within 60 days, either terminate the VBA or implement a corrective action plan to remedy the deficiencies. Finally, for AKS purposes, the remuneration may not be used for marketing items or services to patients or for patient recruitment activities. As the OIG highlighted in their preamble discussion, this restriction can create some interesting timing issues regarding when services are provided. For example, if a care coordinator is provided by a post-acute care provider to a hospital, they should only begin interacting with a patient after the patient has selected that provider through the normal discharge planning process, not before. Otherwise, there is a risk that VBA will be viewed as using the coordinator's services for marketing or patient recruitment purposes.
Thanks, Rob. It's important to note that this discussion has been limited to just a few key aspects of one type of VBA. We don't have time today to provide a thorough review of the many other options that come with the risk-based arrangements, or the other safe harbors and exceptions that were issued along with the VBA rules. If you have other questions, please feel free to reach out to anyone on the Alston & Bird healthcare team for further information. Thank you for joining us today for this Healthy Byte on care coordination arrangements.